Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, Committee Room 30. Sound. 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 Committee Room 30. Sound.
Thank you. Okay, members, we are now being broadcast online and throughout Parliament buildings, and just would like to welcome those of you who are watching online today. Apologies for the delay. We had a closed session very useful, but obviously we ran over time a bit, but hopefully we can catch up. So if we can ensure everybody's mobile phones are muted. Thank you. Will I just take the chair's business after?
Yeah, I think so.
I'm going to take the chair's business in minutes after, members, if you're in agreement with that.
Matters arising then out of that?
Yeah, everything out after that. Okay, okay, so thank you and apologies for the delay. We had a closed session there. So, members, we are now taking an oral briefing from the Department Truth Recovery Programme consultation, public consultation. You'll find the pack at page 57, the clerk's brief. Page 59 you'll find the departmental briefing paper, and page 171 of the pack you'll find the consultation report. So today we have got Martin Carey, the programme director, Pauline Korsgaden. Yeah, Elaine Allen and Francesca Murray, all from the Executive Office, working on this. So if you want to go ahead and make your opening remarks. Thank you.
Okay, thank you, Chair. We welcome the committee's continued support and appreciate the opportunity to update you this afternoon on a key part of the programme, which is the outcome of the public consultation on proposals to establish a public inquiry and associated financial redress scheme for those affected by mother and baby institutions, Magdalen laundries, workhouses and their pathways and practices. The Truth Recovery Programme continues to be a priority for the Department to help address this difficult and shameful part of our past. It is important to acknowledge those who have fought so hard to get to this point and recommit to continuing with the large number of actions in the programme to help provide truth, acknowledgement and accountability. If content with the Chair, I'll provide a short overview just in terms of the consultation report and structure, some of the key themes and then next steps. Approximately 5 minutes, if that sounds okay. So,
thank you.
Okay, turning to the consultation itself and the report structure. As you recall, we briefed the committee in advance of the launch of the consultation last June. We issued to over 1,000 relevant individuals and organisations and advertised in over 90 local, national and international newspapers. We had positive engagement with those who attended one of our 16 public consultation events held across the region and online during the 12-week period. The consultation closed on the 19th of September, following which we carried out a comprehensive analysis of the 269 responses received, with independent oversight from NISRA. At the end of November, we shared an advance copy with the Consultation Forum and Committee, and the final consultation report was published on the TEO website on the 16th of January. At the outset, it's important to say that the report and indeed today's presentation covers what was said, opposed to a departmental response. In terms of the consultation responses, we were pleased there was agreement to the majority of the policy proposals, and there's other areas where positive amendments can be made. However, there remains several outstanding issues where decisions need to be taken on a range of complex and sensitive issues. Noting there isn't a consensus view on many of these, and a wide number of factors including time, legal, equality and funding matters need to be considered by ministers, the executive and the assembly in due course. Members can see that the report is split into 4 sections, and we undertook to present both a qualitative and quantitative analysis aimed to reflect as many views as possible, including minority views, in a balanced way and using people's own words as much as possible. So, secondly, moving into what was said in the report, and I won't have time to go into all of this in detail, but happy to take questions. In terms of the inquiry, we had 9 questions, 5 of which had a majority of agreement. These were the time period for the inquiry, the focus of the inquiry, the power to include other institutions, the consideration of an institution's pathways and practices and connection to the care system, the treatment of burials and unmarked graves. The first area where there was not a majority was around how institutions could be added to the inquiry and whether this power lay with the inquiry chair or the assembly. Other questions that didn't attract a majority were the question on whether each institutional type or who within each institutional type should be considered and how it needs to be and whether it needs to be specified now. Turning to the responses in relation to the 12 financial redress proposals, 5 received a majority agreement, 5 did not, and 2 had an equal opinion. So the 5 areas where there was majority agreement was the basis of the redress scheme, the establishment of an independent redress service, the application process, allowing posthumous claims and nominating a beneficiary. In terms of the 5 areas that did not attract a majority view, I'll provide some detail on this. So the first area related to the eligibility criteria proposal that a birth mother should have been admitted into an institution for at least 24 hours, and instead someone felt that there should be no qualifying period. The second area was the eligibility of private patients in Thorndale House and Lone Place. Some felt all private patients in these 2 institutions should be included, while others said it should only be those who suffered discrimination or were separated from their children, now adults. The third area was the proposed £10,000 standardised payment, with some feeling that this should be higher. The fourth was the next of kin and who should be eligible for any posthumous payments. Concerns were raised around the privacy issues and how the next of kin practice would work in practice. And this is particularly true in the unique circumstances facing the programme and what would constitute a next of kin. The fifth and final area was the date for a posthumous claim and whether this should be anchored to an official/state acknowledgement, apology or announcement. Finally, the 2 proposals where there was equal support or dissent was around the scope of the standardised payment and the timings of both payments. Of those who disagreed, many felt that the focus should be on discrimination and the separation of mother and child rather than a list of institutions. Others argued for the inclusion of other named institutions, including workhouses and private nursing homes from the start. Finally, I'll move on to the key steps in the process. While ministers have given significant consideration to the policy prior to the consultation and post-consultation, they want to meet with victim survivors to hear on some specific areas before bringing proposals to the executive for its agreement, which will in turn allow the draft bill to be finalised. In terms of the process, the Department is also aware of the importance of bringing forward a bill that does not have legislative competence issues and has appropriate checks and balances in order to avoid unnecessary delays. The aim remains to see the introduction of the bill as soon as possible in the 24-25 legislative year. In parallel, the officials will continue to work on the operational plans to establish the inquiry and redress service. And to conclude, we look forward to assisting the committee as we move forward in an important role in this process. So, thank you, Chair. Happy to take questions.
Thank you very much. Any other comments before we go? No? Okay, so thank you so much. We've just had a closed session with some women who have been involved in the consultation forum, and we will be writing to you around the structural issues that we have in relation to that process. I had a meeting last week with 13 other women and adopted parents, very similar concerns, and then the birth mothers and their children for justice, as you know, they've walked away from that consultation forum. So I'm just putting you on notice that that is something that we as a committee are very concerned about, okay? And on that basis, off the back of some of the way you've presented the issues here. So we had the Commission research 2018 to 2021. I want to know how much money was spent on that, okay? I want to know how much was spent on the Truth Recovery Design Panel, the 3-person panel. I was looking there around the independent panel, and that's where a lot of the complaint sits at the minute. So online it says that there are 10 members, 7 are expert, they're paid £500 a day, they have to be a minimum 5 days a month, plus travel, plus subsistence. The 3 individuals from the Victims and Survivors constituency have to be there 2 days a month, again, similar conditions. My estimation is that they have been paid £525,000 to date, and by the time this ends, there will be £735,000, so £750,000. Okay, so we have a fair figure of how much that's costing. We know that alongside that, again, there's the Truth Recovery Consultation Forum, and then we're going to go into an inquiry, and we know that HIA was 17 to 19 million. Are we honestly going to niggle over whether we include inflationary pressures on the £10,000 standardised payment when we've probably already spent about £3 million? By the end of this process, where we're getting inquiry, we'll have spent £3 million, wasting years and continuing to traumatise those women who had their children taken away from them. Is that honestly where we're at, niggling over inflationary pressures on a standardised payment?
So, Chair, happy to come back to the standardised payment and around the rationale as to why the 10,000 was proposed. I suppose the first thing to say in terms of I'm more than happy to provide the cost for the research and for the design panel and the budget for the independent panel. There's no issues in relation to that. I suppose the key part of the design panel was a 2-stage investigation, so a non-statutory inquiry, which was the independent panel, and that was appointed through that 10-person panel. A key element of that role is to provide basically 2 main functions: oral testimony and provide it in a supported and structured way with expertise, and that is a meaningful alternative to a public inquiry process.
So, sorry, just before you go on, who are they supporting? Because I now have spoken to about 20 mothers and adult adoptees. Who are they actually supporting? These experts, trauma-informed practice, gender-based violence, experts in domestic law. I'm not seeing any evidence that people are being paid £2,500 a month out of the public purse are providing that service in terms of this truth recovery process.
I suppose the panel already have had over 100 people who've come forward and provided oral testimony, and that's.
Are these the same people who provided oral testimonies in the 2018 to 20?
Yes.
Okay, so are we able to discount the duplication there, or are we just going round in circles in this process?
Well, I suppose there's a couple of elements to that. So in terms of the previous research, as people have additional access to records, there's additional information that they have and understand and want to have that as part of an oral testimony process. That's important that we provide that choice to people. Some people will choose not to go to the independent panel, and that's equally fine. That's part of their choice as well. If they want to provide evidence to an inquiry, that's absolutely fine as well. So there's multiple choice that people can provide either to an independent panel process, to a public inquiry, or to neither. And I think we have to respect people's choices in relation to that. The second element that the panel, a large part of their work is around archival records, and that's working with PRONI, who have basically got, I suppose, identified at least 4,500 private records. Of those, about 3,000 records have been where there's agreements in place and there's a digitisation process. Those archival records, particularly given the age or the time period from 1922 to 1995, are actually vital. They provide real tangible evidence for considering and establishing basically the 3 core questions that any investigation is trying to look at, which is what happened, why did it happen, and who was responsible. So the work of the panel is vital, and it's an integrated investigation. The design is that an independent panel will feed in and will provide lots of the value and support to a public inquiry. So it isn't nuggetry work, it's important and it's vital for the inquiry. It is a different model than other models that have been undertaken, but I think it's an important model. I'm disappointed to hear that the experiences that you've outlined there, I don't think that's universal. I should say, I think there's been a lot of support, there's a lot of people who've come forward to the panel, and I think we have to respect that people will choose different routes in this, and some people will prefer the public inquiry route, and we have to respect that as well.
Well, I have to say that the people that I've heard with, I know they've been there from the very start of this process, who fought to have the door opened to them down in Castle Buildings all those years ago. So I'll take my lead from them in terms of their experience in this space. But I'm going to move on. So you said that there's not agreement on some of the consultation questions, and I went through them. I totally agreed. Why? And I think that you're misrepresenting that. I think that they're not agreeing with what you are proposing. It's not that they can't agree. I think that there's universal, or not universal, there's widespread support that this inquiry should be as inclusive as possible in terms of the institutions possibly being added and stuff. So I think that the presentation of that is possibly wrong. Don't want you to comment on that because I don't want to hog this. But there's just one last issue, and it is around the standardised payment and then the individually assessed payment. So in 2016 there was a recommendation in the HIA report, and we're still just finishing that process. Does it need to have a statutory inquiry recommendation for this redress scheme to be set up?
For the individually assessed?
Yes.
I suppose
Was that a yes? It does?
Well, yes, that's the model at the minute, that it would require a public inquiry. I suppose what that provides, Chair, is that similar to what the HIA inquiry provided was a systematic review in terms of those list of institutions, and it provided findings in terms of systemic failings. So it provided that sort of framework and structure that an individually assessed payment would sort of require. So what an individually assessed payment is trying to replicate is effectively it's a civil court sort of process, or an alternative to a civil court process. To have an individually assessed payment prior to a public inquiry, I think it wouldn't be possible based on what we've...
But we've spent hundreds of thousands of pounds so far. We commissioned the research, identified them all, then with the Truth Recovery Design Panel, Independent Panel, what have they been doing?
I suppose
they not identified the issues, the institutions, what went wrong, who was at fault?
I suppose the research has helped to illustrate what happened, and I suppose what an integrated investigation, what the design panel proposed was that, particularly in terms of the final two questions about why did it happen and who was responsible, that's partly why the integrated investigation was there. You know, that it was that two-stage investigation that the design panel had recommended. I think in terms of, I should say in terms of the independent panel's work, and I suppose the comparison to the process that has happened in the Republic of Ireland, this has been actually, there's been a lot of support in terms of the two-stage model, in terms of both reliance on oral testimony, and I think the panel have spoken previously about the importance of oral testimony in this process, but also the value of archival records. Unlike the Republic of Ireland, where there was lots of issues about actually getting private records, closed records held by institutions, because of the Preservation of the Documents Act in March 22, we've actually got a really good piece of legislation which has real tangible differences in terms of being able to both access information but also preserve, and it's led to actually a very good set of records that can be used for both the investigation but also to help individuals who are accessing information about their own circumstances as well, which is obviously, and a lot of this is the most important aspect is about truth recovery for individuals.
Okay. Go ahead, Deputy Chair. Thank you.
Thank you. This is obviously a very difficult situation for everyone concerned. The effect review, that the inquiry that is underway is into mother and baby institutions and the Magdalene laundries and workhouses. Why does that not include also the actions of the state in all of this? The state was a colluding factor in all of this. The state colluded with many of these institutions to let them do what they were doing. So why are we not effectively investigating what we, the state, did?
Yeah, and that's absolutely the policy intent, and that is, if that hasn't come across strongly in the Consultation, this is about as going back to the integrated investigation, it's what happened, why did it happen, who's responsible. There is no way, shape or form that this should be limited just to private or voluntary bodies. This is about also the state's role, and that includes statutory bodies, includes GPs, it will include social workers, it will include the justice system. It is important that the inquiry looks at all those elements and determines who was responsible. The institutions, there will be, it's important to understand what happened within the institutions, but one of the key aspects of this is around pathways and practices. So basically, how did people move into an institution, how did they move out, and what were the practices that led them to that institution? So that, just to reassure, this is designed to look at basically the experiences not only of institutions but the state, and it could also extend to individuals and organisations. So that there should be no bounds to where an investigation can look at and determine where there was responsibility.
Because it's clear the state gave legitimacy to a lot of this abuse.
Yeah.
But it seems to me to be always very difficult for the state to put its hand up and say, we're part of this. It's a bit like the post office scandal.
Yeah.
It's their fault.
Yeah.
But and everybody knew about it, but nobody did anything about it.
Yes.
And it's that aspect that, you know, even in the title of what you're doing, reading this, you know, this is an investigation into mother and baby institution, Magdalen laundries and workhouses. I don't see the word state in there anywhere at all, nor do I see any reference to the state in that title at all. I think you need to be more open and more honest. This is about investigating what our predecessors in the public sector did in delivering all of this.
Yeah, no, I completely agree that this shouldn't be restricted to just looking at what religious or voluntary bodies did. It is about the state's role in this as well, and I suppose a key aspect of that is understand what the state's registration, regulation and inspection role, particularly with the institutions, is, but that's not a limitation, so it can look at basically the role of health professions and justice as well, which are probably the two main areas.
Effectively the blind eye that was turned because of what was going on.
Exactly.
Can I second question? Can you just take us through who appointed the independent truth panel?
Yeah.
How that was appointed, and how each individual was selected for that role?
No problem. So the design panel, which was sat from early 2021 and reported in October 2021, they basically recommended that two-stage investigation. The independent panel is that non-statutory element. It was appointed through a public appointments process. So each there was basically the 7 expert members as the chair sort of alluded to in terms of particular disciplines, and then 3 victim survivor representatives as well. Each of those would have went through an application process, an interview process, and then there was basically through that public appointments process they were appointed. It was under the Executive Functions Act, so there wasn't ministers in place at that time. So that was the process. Those panel members are obviously, there's an appointment letter around that, and that's an important part. They are post holders, so that's an important role that they have, and I think that the process is a difficult process. There was a lot of discussion around particularly how victim survivor representatives would be selected as part of that and through the forum process. And it was through that public appointments process that was deemed the most appropriate.
And therefore, as a public appointment process, was that guided by the Public Appointments Commissioner in Northern Ireland at the time?
Well, it would have been in the spirit of the code, so I would have to check.
In the spirit and not in the reality?
Because I just want to double check in terms of the official, I think the Sapani Code would only apply to particular appointments, but if you're content, I would be happy to write back just to confirm.
I think we need to understand.
Sure.
What is. And you describe these people as post holders, which is
That's right.
which is a specific legal entity.
Yeah.
That therefore presumably requires them to meet a range of standards, not least of all the Nolan principles in terms of that appointment.
Yeah, it's in terms of the appointment letter, I think it's specifically the Northern Ireland Civil Service Code of Conduct, which I suppose is in line with the Nolan principles. But yes, that's the
in those
principle.
Circumstances, if somebody had a complaint against a panel member, how would that be dealt with?
So a complaint, and we should say In general terms, if a complaint is found, it would first of all depend on who it was in the panel. So if it was a panel member who wasn't one of the co-chairs, it would first of all be considered by the two co-chairs. They would basically, I suppose, standard in terms of they would assess the facts, consider if there's appropriate actions, and then provide a response to the individual. If that individual is unhappy with the response they receive, there's an escalation process that it would come to a senior official in TEO, which would be myself or Gareth Johnson as Deputy Secretary. If they're unhappy with that response, there is then the route around the Ombudsman. That's sort of the panel process. And I suppose similarly, if there was an issue with the TEO official, that would go through a TEO complaints process. So it just depends on who, either within the panel or if it's a complaint about one of us, for example. So it depends on who it is. But that's the principle. There's a complaints policy on the panel's website. There's complaints policy on the TEO website. So there's a clear process there. So
that complaints process been there from day one?
I would have to double check if it's been there from day one, but it's been there from early on in the process is sort of how I would describe it. Thankfully we haven't had to use that process very much, but it is there, and the panel are dealing with, they've dealt with hundreds of people through their work, and the same in terms of TEO, we're dealing with hundreds of people, but it hasn't been used extensively, put it like that, but I'm happy to come back.
But there's a clearly written process with timelines and requirements.
That's right.
Against that. So can you provide us with a copy?
Yeah, no problem. It's available on the website, but yeah, happy to provide it.
Thanks, Chair.
Thank you. Carol, please.
Thank you, Chair. I thank the panel. I looked through the consultation and the questions again, and there's absolutely nothing about the state, even the language used by pathways and that. It's far too nuanced for me. So it would actually need to spell all those out. The questions I have really, I mean, the point that Paula made has came across, I would say, at least 3 or 4 occasions, in terms of while the 9 questions were there and the 269 responses were made, it's quite clear that it's not that they just disagreed with the question and the way that it was put. And it adds to the sense that a lot of, particularly the birth mothers, feel that there's been a whole lack of empowerment or recognition as part of this. In fact, the whole experience of all these scandals was based on a way that misogyny was at the heart of a lot of their experiences, or their birth mothers' experiences, and they feel completely disempowered. Can you explain to me, so on, for example, the note that we have, you've alluded to the draft bill that's coming forward, and very helpfully said that you would be sharing the bill in confidence on the draft bill in advance of its second stage. Why is a bill which is a public process been shared in confidence, and why do some of the people feel that they've had no say in what some of the things, their experiences, should be reflected in that bill? Could you respond to that accusation?
Yeah.
And then my last point, Paula, is that why can you explain the mechanisms of, and it's probably something that Paula you'll want to come back on, but certainly the consultative panel and the independent truth recovery panel, it seems that the department is the kind of filter or has the last say in how people are contacted and how they participate. It just seems to me that it's a very patronizing and disempowering process. So, and that's what the appearance is. So I would just like to hear from yourselves why it was done in such a way, because it's clearly not working for so many people, much of which are women survivors.
Okay, Cara, I want to clarify just on the just before in terms of the panel. Are you saying about this is how people engage with the panel is through TU? Is that what are there were a barrier? Is that
well the first of all, the panel isn't engaging in the way that it should. That seems to be consistent across the board. That there are accusations of a misogynistic approach, and that the engagement isn't done through a gender lens. And when they've raised concerns, even about transitional justice and gender injustice, they feel that they're hitting a brick wall. And that's I've heard that too often from different groups of people. So I'm not dismissing it. That's their lived experience.
Yeah.
So that's an issue, despite the fact that some of the experts on the panel have backgrounds in human rights and gender justice and gender equality. So I don't understand why they can't get access to those panel members. This is the members on the consultative forum. And as you know, the Birth Mothers for Justice are completely separate because they've had no confidence in the process at all. So there seems to be too many layers of people who need support and services can't get access to it. And the consultative forum can't even get access to some of the people that they may need to reach out to in advance of the imminent date of closure of May this year for their personal testimonies.
Okay, so I suppose just thanks, Carol, for clarifying that. And I suppose in terms of the panel, I should say that I think they're due to. I think are they appearing at the committee at some stage? Is that?
Vast. We don't think we've got them in the forward work programme, but after today, I think we are going to expedite that.
And I think there's a couple of elements that I suppose. I think it's vital, and the panel have put in a lot of work into try and make it accessible for people. So I think that's obviously a concern, that if some people feel that they don't feel as if they can come forward to the panel and have access to panel members. I suppose there's a few elements that the panel have engaged on specifically recently, and I know there's a lot of future engagement planned between now and the closure of the oral testimony process on the 1st of May. So I want to sort of ensure that the panel are independent from ministers and the department. They have a terms of reference which outlines what they're expected to do and what they've been appointed to do. There is, I think, a lot of expertise within that panel, and I think there's a lot of, in terms of particularly how this has compared to processes in the Republic of Ireland, there's been a lot of support for the model, and there has been a lot of people who've come forward to the panel as well, but I appreciate that isn't universal, and that is a concern that some people don't feel that they can come forward to the panel. Just, Carl, maybe to go back to your earlier question, I think it was just in terms of the draft bill that I think that was just maybe the way we presented it. That we're saying it, that obviously the bill will be introduced in the Assembly and it will be publicly available to everybody. It was just about providing if there was an in-confidence briefing that the committee wanted, or a public briefing in advance of second or committee stage. So that we're just offering that. It's obviously would be all publicly available from introduction. So hopefully that clarifies on that. So I don't know, Carol, does that, I mean, the state point you made, I mean, we've tried to particularly in 3.5 of the original consultation, is basically tried to outline that it's not just about institutions, it is about the state, including cross-border elements as well, so across multiple jurisdictions. The role of the judiciary, because I suppose whenever we look at early life experiences within adoption, there is definitely the ad litem type decisions. There is a role there about how people were separated from their mother, and then basically how they were placed either in foster or for adoption. So there is large elements of records, both statutory and but also practices. We haven't, if we're honest, in terms of people who have come forward to provide oral testimony, it has been primarily victim and survivors to date. So it hasn't brought forward as many people in either from institutions or from state, so basically social workers or people from the judiciary. That is a bit disappointing, to be honest, but there has been efforts to bring people forward, but people haven't come forward. So.
Are you, Carol? Yeah, thank you. Brian, please.
Thank you, Chair. First of all, I do wonder why this process is so far behind other institutions where abuse occurred. I don't know, I mean, is there an explanation for that? I mean, the redress scheme for other schemes is actually due to close in a couple of months, and this one, we're consulting about it. Is there any idea, and I know there's still stages to go through, could any indication be given of when a redress scheme for the Mother and Baby Institution, Magdalen Laundries, workhouses, when it might open?
Yeah. I suppose, Brian, to be honest, the next stage in terms of introduction in 24-25, that's we want to introduce the bill this legislative year. I suppose, as we've outlined in the consultation on page 14, it's basically the timeline. These are the things we need to happen pre-introduction. So that includes executive agreement, includes the speaker sort of considering in terms of competence. There are lots of ECHR and human rights aspects which we've tried to reflect in the consultation documents that are important, that will need to be considered in terms of competence. Then once it goes into the assembly stage, I suppose that in part will be a decision for the committee around the duration of the committee stage. I think a 30-day sort of standing order or 30 working days. This is such a complicated bill. It is a really complex piece of legislation, particularly on the redress side. It is a demand-led scheme. There's lots of equality issues that need to be considered. It sort of feels like there has to be appropriate scrutiny around that. That also has to be balanced by the age profile.
Yeah, well, I didn't expect to be able to give a specific answer, but it's the question people will ask us.
It's very obvious.
But more specifically, why has this been done as a different process to other institutions? Why were they separated?
Yeah, I suppose this goes back really to September 2011, whenever there was an inquiry announced in relation to HIA. I suppose once Judge Hart was appointed, he considered that it was too much to do all of the institutions all in one inquiry. So he said, instead, I'm going to look at basically children, people under the age of 18. And then at that stage, through the interdepartmental working group, there was both clerical abuse and truth recovery, or the Mother and Baby Institutions and Laundries were in a separate process. So and that's a little bit of the legacy behind it, but and we appreciate there's been a lot of the people who've been campaigning for this have campaigned for a very long time for it, and it is important that both the inquiry and the redress is taken forward as quickly as possible. We're committed to that. So.
Right. Okay, and will there be contributions from the institutions be sought? And I listened to other colleagues talking about the culpability of the state as well. But at what stage is that process also at ground zero currently? Is there a whole process to be run through, or is that being pursued along with the existing process for the children's homes and so on?
So it will be a separate process. And Brian, the key aspect around contributions, and it goes back to the investigation, is sort of the three core questions. And I know I keep on repeating this, but it's helpful just to sort of frame the investigation in terms of what happened, why did it happen, and who was responsible, and particularly in that third element around who was responsible. And that's partly where a sort of public inquiry can provide I suppose more powers. They have more powers than a non-statutory inquiry, and include the powers to compel. That in terms of who was responsible then provides sort of findings to say these were formal wrongdoings in these institutions which were conducted by these institutions. So that provides that framework in order to seek meaningful contributions. The policy intent from the department is very clear. Those who are responsible should be making contributions. We want that to be on a voluntary basis, so similar to the HIA process in terms of negotiation, mediation, and then arbitration. That could be a framework that is used. if there's other methods or models that we can use to bring forward contributions quicker or in a different way, we're happy to consider those as well.
Okay, and last matter I want to raise, perhaps more of a comment. I mean, I was surprised the question asked about whether women and girls who entered mother and baby institution as private patients, whether they would be eligible or not. Now, I welcome that 70% disagreed with the suggestion that private patients would be excluded, and I hope that will be reflected in the final outcome. I noticed the comment there in your text on page 54 of the text of your report. The independent panel noted that private financial arrangements were a factor in some cases where there was a desire to avoid state scrutiny of a pregnancy, such as cases of incest or child sexual abuse.
That's right, and those are, Brian, some of the most extreme aspects. As I would say, Brian, maybe I think in terms of the policy, it wasn't to look at private patients in general. It was just specific to Thorndale and Malone Place. There's a very specific element in Thorndale as an example, and I'm going to use a very sort of crude example, but we could have had basically an individual, a single unmarried mother who went into Thorndale to give birth, and basically that would have been a practice that Thorndale would have accommodated. We could have had another individual who was using Thorndale as a private, it was basically a maternity business. It was a private business where, you know, they could have lived up the street and they went to give birth in Thorndale. So what we were trying to get views on was about the eligibility of those two sort of cohorts. So I think the recommendation is, or the consultation has highlighted that there's an element of explaining that it doesn't apply to other institutions, so it's just specific to Thorndale and Malone Place, and it's primarily because they were dual purpose. They had multiple purposes on that, but that's something in terms of for ministers to consider. That's definitely important.
So it's trying to determine at this length, you know, recognise where the coercion still was taking place. You know,
exactly, and there are some very extreme cases, particularly around married. So we've made a very clear distinction on the policy not to distinguish between based on marital status, partly because some of the most extreme cases are actually cases of rape or even incest within a married mother. So that's something we've tried to avoid in terms of sort of making that separation or segregation. So
okay, thank you.
Thank you. Sinead, please.
Okay, thank you for coming in and giving us a summary of the responses. In the executive summary under general themes, I think what I was saying is page 79. The first was the need for a trauma-informed and victim-centred process, taking account of the wider family and intergenerational trauma. Do you believe to date that you have taken a trauma-informed and victim-centred structure in everything that you've done? And added to that, do you consider that you have been taken a gender-informed approach, and have you really clearly understood that gender lens in all of the processes? And so, and why I'm asking that is because some of the questions and the responses that you've given, I feel that those responding feel that they haven't, that those key themes haven't been clearly engaged in the process. So just from your perspective, talk through the trauma-informed approach to the victims through the actual consultation itself.
Through the consultation itself. So I'll maybe bring Pauline and Francesca in just to talk a little bit about the consultation events, because we've tried through that process to make sure that basically we purposely put on a lot of events in order so that they were small groups, and basically tried to provide a supportive environment for people to come in, give plenty of time and support pre and post. So that included having counselling support on the premises. So that was through Wave, who had dedicated counsellors at every single event. We also tried to, through the consultation process, is to break it up into both the inquiry and redress, and give plenty of time pre and post. So I think that was part of the consultation. I suppose, Sinead, we've always tried to be trauma informed in terms of supporting people through this process. That's not to say there hasn't been times whenever we haven't met the standard that we would like to meet, and that includes basically some very difficult meetings and some very challenging meetings, and we're not in any way sort of there's some things we've got wrong in the past, and we acknowledge that, but that's not through lack of effort, and it's not through lack of trying. We understand the importance of this. We understand, and I'll maybe let Pauline talk a little bit about the work we've done in terms of a group and trying to build that safety. And a key aspect, I suppose, is about choice in this as well. So trying to provide as much choice for people to engage in this process. For some people, that will be an online meeting once a month where they can go through all the detail, and for others it is they want to meet and they want to chat and they don't want to talk about the policy at all. So it's trying to provide.
Have you got data relating to those that have sought to meet face to face against those that have met online? Because we've spoken to both that have done both, and some of the experiences have been really difficult.
They have.
And I know the department has had to bring in support.
That's right.
Supporting people to engage in a process.
That's right.
It questions the structures of the process itself. So I just want to understand that, because what you don't want to do is develop a structure that is traumatising to the individuals, and also that gender lens as well, because that is very, very important, and the department has a big role to play in that, but so has the panel, and so I just want to understand both of those.
Well, maybe, do you want to take?
I can maybe talk a wee bit about the consultation forum. I mean, there was a review, an independent review of it carried out, because it was very clear some of the meetings have been very difficult. They have been very emotional for people, and that includes officials. It was recognised by everyone attending that it was not always a safe space, and that the principle of do no harm, which was an underlying principle of why the forum was set up initially, wasn't being adhered to across the board. So that is when we engaged Dr. Danny Taggart. So he's a clinical psychologist. He has worked along with our outgoing chair, Avila Kilmurray, and an invite was extended to all of the consultation forum invitees, which is over 90 people, to engage in the process, be it online. So Danny and Avila held, probably from April to December past, over 20 sessions. And that was with, those who volunteered, who wanted to talk. The purpose of it was around reviewing the forum. What did victims and survivors need, want out of it? It was about increasing the safety of the engagement and how we would collectively do that. It was about advocating, and it was about coming up with proposals for an improved structure. So that, along with the independent review carried out by our colleagues in Business Consultancy Service, we do have a different type of model. Face-to-face isn't always possible. It's the nicest thing to do given the subject matter. But because we have people across the world as part of the forum, it's not always easy. And people are also working on different time zones and the like. So the space was given to forum members, and they opted in, or, if it wasn't for them, opted out of attending those sessions to help shape a revised forum. In addition,
just before you go on, so recommendations for improvement, have you gone back to see if the recommendations changes have actually improved?
Well, they only finished their work on the 7th of December. Okay. So we have a draft invitation. We also need an interim chair, and that has also been something that the victims and survivors were heavily involved in. They created a long list of potential candidates to take over from Avila. They fed that through to Avila and to Martin, who have shortlisted it. And we're in the process of now arranging a meeting. We would hope in February to hear from those who are interested in becoming the interim chair and putting forward a proposal for engagement. The engagement will be different. We're in a different space in terms of we now are through the public consultation. But what I will say, Martin and I, as well as the 16 public consultation event, we actually held face-to-face and online smaller engagement sessions with the birth mothers and their children for justice in July last year, with TRNI and with others, and that was between July and September. It was an opportunity not only to meet face-to-face and put the human face of all of this in place and to build those relationships, but also that was an opportunity where it was the public consultation. What is it that you need clarity on? And to be fair, they were also involved before it was launched in helping us refine language and terminology, which was a very powerful and positive thing before it launched. And those smaller engagement sessions absolutely worked. And it wasn't just about the questions in the public consultation, it was about the programme in general. But it is true to say that the public consultation has taken precedence, quite rightly. We need it to move forward. But we would expect engagement. It will be different, and it is based on proposals that Danny, as a clinical psychologist, has felt will be beneficial for all involved, and especially for the victims and survivors. I would also say that, our mailbox, we have a mailbox, we've had over 3,000 emails that we have managed, and a lot of that has been around working with victims and survivors, in terms of where they've maybe struggled with access to records, being that conduit, between getting them that support. So there probably is frustration. We do have a group of people who aren't always in agreement. That in itself creates issues, and I think it is fair to say that could we do things better? Absolutely, but that is a will that's needed from everyone who attends to get the best out of it for everybody.
Thank you, and I absolutely appreciate that this is very, very difficult, and the nature of trying to get to truth and recovery is not an easy pathway at all. So are you saying to me that the whole process of the public consultation and the design of that consultation was very much co-designed between the victim and survivors and the department and the panel? Because we are being told by some members that they felt outside of the process, that it was designed for them but not with them, and that is difficult as well, because you need the victims and survivors to walk with you hand in hand in order to get to that truth and recovery. And if anybody feels that there are, questions been manipulated in any shape, form or fashion, or like a predetermined answer that was required, then they're not engaged the way that they should be, and again traumatized, and again the clinical psychologist, I'm sure, has informed you of that, that the whole process is very
that's why the work and the time that Danny and Avila have taken with forum members, it was important to go at their speed and at their need, rather than continue to have a monthly forum meeting that was clearly doing harm, and it had been recorded that it was doing harm, and it would have been very remiss of us to continue with that process.
And another question, I know there's others that want to get in here as well, and I'm sure we might have to come back and ask you some other questions, but they feel that they haven't got an authoritative voice to advocate on their behalf, because as you said, it's a very big forum, 90 or so members in it, and they don't all get together as one in many ways, and they have different prioritisation and confliction possibly between maybe mothers and adoptees, and it's where, you know, who speaks the loudest in a way, and that should not be, that can't be. So what has happened, and you know, there possibly could be a request to have a commissioner that will advocate on their behalf and be their fighter in this process, so that they get clarity in that. How do you feel, I suppose maybe this is over to you, Martin, how do you feel about that advocacy role? Because they do feel that their voice of the collective is not actually represented appropriately for them, and sometimes the panel is nearly an obstacle to them.
Yeah, and I suppose advocacy and voice about how that model works, Sinead, we spent a lot of time thinking about how this should work, in terms of, this is an unusual process that you would have a forum that has lots of different types of victim survivors in one forum. So that's the first thing to say. I think we're open in terms of, if there's a different model of advocacy, if that includes, you know, an advocate role, that's something absolutely, if that would help and improve, we're absolutely open to that. But I suppose what we don't want to do is basically reinforce that if there's basically different views, that we don't want to sort of consolidate that in one individual, and I think that's something that we would just need careful consideration. I think Patricia Carey, who is the Special Advocate in the Republic of Ireland, provided Avla and Danny facilitated some session with victim survivors prior to Christmas on that model. There's, I think, lots of positive feedback around that model. That's also a very difficult role, a very challenging role, and we've got some of those roles here as well. So I think it's we're definitely open to that. It's just about how it works in practice. I suppose what we'd like to do is maybe have, Avla has done a really excellent job in supporting us through this process and lots of expertise, and it's just Avla's, just due to other commitments, is stepping down, so we're maybe thinking about an interim sort of role for a period to try and support.
I think that's key, and I have the greatest respect for Alva and what she does in many forums. And it's, I'm not in any way questioning that. However, I just think, you know, for that enhancement of the collective, that possibly would require a commissioner at that level. We have seen it, and we worked through that, and we know the value of it in this committee.
Okay, thank you. Timothy, please.
Very much. Obviously, it's taken a lot of time, an extortionate amount of money to get to where we're at, which is causing much frustration. You have mentioned voluntary contributions. Very, very interested in what do you think the direction of that is. When we look at the HIA redress, basically we have had to go, there's some of the institutions have paid, some of the institutions you're chasing. Will the money ever come? I have no idea, but it's always been the government paying the money up front. Is there a way of looking at this that voluntary is optional? You can pay or you can't. It's about time TO, the government, the executive, whoever, you know, hits the table a thump to say people deserve compensation. They deserve compensation to deliver justice, to get some accountability for what has happened to them. What stage are we at? HIA, we're going down the route of how are we going to fund specialist services? Is that something you are already considering? So when you are going for voluntary contributions, in my eyes it should be contributions, this is how much you're going to have to pay. But it's not just about one-off payment, it's about one-off payment, a support package to meet the needs and to recognise the damage that has been done for them people, to support them for the rest of their lives.
Yeah, I suppose, Timothy, just to agree with you in terms of, and this is both from a departmental but also very important from a victim survivor perspective, that there is that accountability, that there is that responsibility, that there is contributions made in relation to this, so that it isn't just a state redress scheme, and that there is contributions. The voluntary aspect, I suppose we have tried to look for sort of precedents and looked at other. They are normally, in terms of other jurisdictions, it is on a voluntary basis. That's not to say, and I suppose the HIA as an example, we have had those institutions who have made voluntary contributions, and that process is there and has.
It's not a best practice certainly to follow in my book.
Well, yeah, I suppose we have looked at other jurisdictions just to compare, and I think most of them are that sort of voluntary basis, and I think in one way, I suppose, taking a step back in terms of sort of restorative justice process, or that feels more appropriate as well. It should be that institutions or bodies that should include the state. The state has a responsibility, or will have a responsibility in terms of.
The state is paying for everything that's happened to date, and
that's right.
So that can't be just discounted. Like, the state is paying a massive amount of money to get us where we are. It's now time that we start to make sure and ensure that those responsible pay their fair share.
I completely agree with that. That it is important. I suppose there's a question on timing. So, at what point does that responsibility? As you'll probably be aware, in the list of the institutions, there are lots and lots of institutions there. It's trying to understand, did all those institutions operate in the same way, in the same practice, and that provides a basis then to determine who is responsible and whether it was systemic, and that then provides that basis to then seek contributions in relation to the bodies who ran those institutions.
So it seems to be now the consultation responses have come back. It's almost a period of reflection. That's what's coming across to myself. You've talked about difficult meetings. You've said there's some things we've got wrong. You have mentioned phrase probably creates a frustration. We've dealt a bit earlier on with complaints, and you've said thankfully there hasn't been that many complaints. But it seems to be that the victims who should be at the centre of all this feel very disconnected and unhappy of how things have, got to where we are today. And certainly while maybe a period of reflection isn't the right term to put on it, but that's certainly what's coming across from the panel. There needs to be a step back and looking at that. And Sinead has mentioned about the advocate. A victim's advocate should be at the heart of this, and then everything you're doing is around it. I would be interested to know more. So we've talked about the complaints process, but what's the feedback you're getting of how well this is run to date, and what is the complaints, the concerns that have been raised with yourselves, and what could you do better?
Okay, so there's quite a lot of questions there. Also, try and answer. I suppose, I think again, taking a step back, this is such a difficult policy area. This is not a policy area where you can go and. We've engaged on lots of different areas in terms of precedents, and unfortunately this policy area in other jurisdictions is also very it's very difficult to sort of come up with the balance between the time and the inclusion and the affordability considerations. Those are key aspects that we have had to try, and I hope that's come across in the consultation document and the responses. I suppose, Timothy, we've tried to reflect as much about the views of the victim survivors in the consultation document itself, and use people's own words. I think you're right in terms of a period of reflection. It is a period of reflection, and I think consultation, I think we have to acknowledge that not everything in the consultation people liked or agreed with, but...
You did get to that point.
But I was going to say... But I think we have to take a step back. The majority of the proposals people, and I think we have looked at other processes. We've designed a scheme which is particularly on the financial redress, which is much more inclusive than the Government of Ireland scheme. So in our scheme, we have a £10,000 standardised payment for birth mothers and any child born to that birth mother in the institution. Where you look at the Republic of Ireland scheme, if you were in a birth mother in under less than 3 months, it was about €5,500. If you were a child, you had to be in the institution for 6 months in order to get a redress payment. So there's actually, in terms of the design on the policy, we've tried to be much more inclusive. I mean, appointing an independent panel with victim survivor members on the panel, that is about trying to bring forward a victim survivor lens, both to the investigation and how that the investigation and the terms of reference that they have. We've also got large elements in terms of archival records, and we've seen some real, last time we were here, there was real issues with access to records, and there is still issues with access to records, but there's been really, really big improvements in terms of the practice guidance, in terms of how that is actually operated in practice, and people are getting information that they previously weren't able to access. Over and above,
There are still issues. There are still issues. Yeah.
Yeah. And there's some quite serious issues as well, and I'm not diminishing that.
Okay.
We've also got a support model with VSS and Adopt NI, which over 300 people have accessed. The feedback on that has been very, very good and very supportive, and a wide range of support services available. So I think you're probably right in terms of period reflection. As Pauline said, like we can always try and do better, and we can. Our intent is to basically move this forward. We have to move it forward in terms of the redress and the inquiry.
A couple of questions then. So the members on the Consultation forum, we've mentioned that group, and supporting forum members, they used to have monthly meetings. Who attends that, or does anybody attend that from a TEO? Can you give us feedback of why are these meetings difficult? Is it the way they're chaired? Is it the way they're run? Is it conflicting ideas or priorities? I want to understand why, when you're bringing a group of people together with a common cause to get an outcome, why are we experiencing all these problems?
So I suppose the first thing, and I will bring Pauline in on this, prior to the consultation, Timothy, there was basically, particularly on policy areas, and particularly there isn't necessarily a common view on issues. That's the first thing to say. So there are, and I hope that's reflected in the report, that there isn't a consensus view from victim survivor groups on some of the issues that we've outlined. That is in part, basically, there's sort of interpersonal elements within victim survivors, but collectively there's also frustration, or has been frustration, with TEO and some of the policy positions.
And when groups walk away from that process, is that because of feelings from TEO, or who,
I suppose, I mean, I think there's a mix there in terms of, Timothy, there's probably some of it is around, I think in terms of one group in particular, I suppose the time it's taken, and I think there's the priority to bring forward legislation in relation to inquiry and redress. I suppose my sense is that it is about action at this point. It isn't, there's been periods for consultation and there's been periods for action, and I would say that there's one group I can think of, and I think at this stage it's about...
They think it's inaction.
They think it's inaction.
And essentially this process is wasting their time because it's taking too long.
I think they basically think that, I'm paraphrasing here, I don't want to put words in their mouth, but my instinct is that they think the policy is clear in terms of what the design panel recommended, and it is about moving to the next stage, which is establishing the inquiry and the redress scheme. So.
But that isn't a consensus view by all of those who would attend the forum, so that in itself then creates difficulties and, maybe friction between victims and survivors. It's not just with officials, and that is what has led to, the review of the forum, where people were saying this is not a safe space. Mm-hmm. This is doing harm. It's not... it's not being managed in terms of the do no harm, simply because there isn't a consensus view by victims and survivors about who's in, to put it crudely, who's in scope, who's out of scope, and that in itself, does lead to friction, which is why then Dr. Danny Taggart and Avila have taken that time with forum members. But as I say, it's an opt-in, so those who come to those sessions, have helped shape proposals. What I would say, those who maybe have not been at any of those sessions, I am in contact with. I still have that relationship with that particular group. I understand their frustration. It is a very clear-cut thing for them. It's very clear in the report that this report, includes them, and we understand the frustration, but not everybody is of that mindset. And what the public consultation endeavoured to do was to get that broad spectrum of, views in order to help shape the legislation.
I find it hard to comprehend how we've got to where we're at and how there's this animosity when this is a government-led scheme with the terms of reference, and how when you have one out, and I know you can't keep everybody happy, it's hard to do that, but surely there must be a far better way of managing this. It seems to me the wheels are coming off the wagon here.
Well, I wouldn't characterise it like that, and I don't want to. We've sort of focused on there's been a lot of achievements in the last 2 years, and I'm happy to go through those and basically outline, and I don't want that to diminish. And I think the consultation itself was actually a really big step forward. We got and I should say the 16 public consultation events that we had were actually, I thought they were excellent in terms of the engagement. We had people who had never been part of the process. This one of the biggest problems in this policy area is that shame and stigma is still there, and it was a big thing for people to come into the public consultation events, and we supported people through that. And I think the feedback from the events was all very positive. And I should also say, I think the 269 responses we've got, it wasn't just about the quantity, which we're pleased, it was actually the quality and the time that people took to provide responses, and I think we hope that we've reflected that in a good way in terms of the report. We've tried to reflect as many views as possible, and so I don't want you sort of to go away thinking that there's been a lot of progress in the last 2 years, but there's been a lot of bumps in the process, and I think we're committed to trying to smooth out those bumps. But that's not to say there's still been a lot of achievements in the last 2 years, and we want to sort of acknowledge that as well.
Last thing, so looking to the future, have you a timeline of when we'll see progress?
So, well, the next big step will be bringing forward the legislation in 24-25 legislative year, and that's subject to the executive agreement. But that's the next big step. Timothy.
Realistically, will it be here before the summer?
Yes, that's our aim. We want it to be. I suppose the question is just how quickly before the summer. As
that'll be 25-26, is that?
But yeah, so it's
yeah. Before the summer. That's what we're aiming for, and there's some things that are outside of the department's control, but that's what we hope. Okay, so a question from somebody who's watching online. So the standardised payment, have you got a timeline for when they will be? No, it's sort of tied in terms of, I think once we've got, I think, the introduction of the bill, I think it's then we've got a timeline. That's sort of, we can, once it's introduced in the Assembly, and I suppose there will be a discussion with the committee just around how, I think 30 working days that feels quite tight for this policy area, but I suppose that's something we will have extra sessions if we have to, sure, to get this through the scrutiny stage. You can be assured of that. But I'm conscious that you've said at the back of the report that you'll then need separate secondary legislation. So we'll have the primary bill, and then I know that you can't have the bill drafted until you've decided, right? But are you doing a lot of the groundwork, like getting the panel members there, getting the, so that whenever things happen, then you're ready to move on, so you don't have to start a new process? We've already started sort of operational plans, particularly on the redress side. So about trying to look at, and even in terms of policies, procedures, even trying to look at IT and all of those practical steps, and similarly on the redress. I suppose secondary legislation, we have a fairly good idea of what would be in the secondary. So I suppose once as the primary is passing through, it's about making sure that that's reflective, so that we're not sitting with a long period on secondary. So all that work is in course. So.
Okay, well that was quite a lot to get through today. The only last thing I have is the consultation forum, or people who were on your database, received that 80-odd page report last week.
Yes.
Maybe it wasn't the best practice to send that out. Is there going to be some sessions when you can actually speak to it and explain what actually is meant by it?
Yeah, we're happy to do that. I mean, we sent the original. It was sent out in March, or sorry, in November, at the end of November, and there was opportunity for people to comment on. But if there's separate sessions, I suppose.
Was there not something sent last Wednesday?
There was.
Yes, that was the thing.
There was two. So there was a draft sent at the end of November, and then the final.
Okay.
And there was minor changes between the two.
Okay.
We basically asked victim survivors if there was any sort of terminology or issues, and there was maybe 2 or 3 things that we reflected in that. But like, there's happy to do extra sessions around what
it's just
what
that some people just understand differently than reading or presentation stuff. So
happy to do that.
Okay, thank you so much for your time today. Thank you very much. Okay, members. So have we got? Have we any thoughts then in terms of any additional actions, or apart from the ones we agreed after the last session? No. No?
Natural
Okay.
follow-up, then
Sure.
the independent panel.
That was
coming.
just a wee second, Carol. Sorry, go ahead.
The independent panel, so when they're coming, they're in the forward work programme, is that something, while this is fresh in our heads, can we try and prioritise it?
I was going to schedule it for March. That's the closest we have for free sessions.
Early March?
Yes.
Good.
Yep.
Okay. So about five or 6 weeks ago. How are you? Carol, please.
Yeah, that was one of my questions, Chair. When do we anticipate the panel coming in front of us? And then the other thing is the the cut-off date's in May, and I'm aware that there's been social media and that for people for their personal testimonies. Would it be worthwhile us writing to the outgoing chair, Avla, of the consultative forum, just to see if there's anything that that we as a committee would need to have particular attention to? Because I just, by the time Avla Murray goes and you get an interim chair, I don't know, what the timeline for that is, but those people definitely need an advocate. So if we can include that as well, please.
Thank you. I suppose I'd like a wee bit more clarification. So in the letter from the Truth Recovery Independent Panel, they said that they'd received a budget recently for an online campaign. Somewhere in the back of my head, I think that was 30,000, but they'd already received 30,000. So I'd like to know what money and resources have been put in to trying to get people to come forward to give their oral testimonies, if that's okay. Okay, members, we're going to go back up the agenda and I'll try and be as quick as I can, okay? So, where are we? Oh yes, okay. So just church business then. So I think some of you were at the CAJ Amnesty event on legacy yesterday. I've asked for the slides, so we'll share those. We have got the Independent Commission on Reconciliation and Information Retrieval. Getting tired. They're coming on the 26th of February. So I want to see if you will agree to us writing as a committee to the NIO official to get an update on the repeal amendments process to the legacy legislation. People are in agreement, find out where we're at, okay. So members, we were seeking maybe to try and get a draft press statement out today on the hearings, at the start of the hearings for the Bomb inquiry circulated today. I think you'd sent through an amendment, Timothy, so we'll maybe see if we can get that signed off. But I think just as a comment, I think we're all delighted to see this taken forward, and I'm sure it'll be a very challenging time for the victims and the bereaved, but it's good to see it going.
Did you want to discuss the amendment, Chair? Or
do you want to speak to it? Yes, please.
Just the suggested amendment by Mr. Gaston is to add The committee, noting its own experience of difficulties dealing with institutions which are based in the Irish Republic when it comes to institutional abuse and the shortcomings in engagement with the Kingsmill inquest, urges full cooperation from authorities on both sides of the border so that the whole truth can be obtained.
Any thoughts?
I wouldn't
I
agree
just think
with it.
that's really political, Chair.
I think we're wishing them well, but this is not our role. I think.
Honestly.
I'll let you finish before I make go.
All right, okay. Sorry, Cara. I think I came in.
No. I think Carol was making a similar point.
Sorry.
It's too political. Go ahead, Timothy.
Well, the reason for it is that it's obviously within issues we've considered in this committee. It highlights obstacles that we've come up against. It's a suggested amendment. It's one I would propose, and if we have to take a vote, and if the vote doesn't carry, that's okay.
I personally think it detracts from the sentiment of but as you know, we've asked for the RAISE to do the research into the role and potential shortcomings of the Irish government in terms of engaging in these processes, and I think that possibly we could look at something more substantive coming from this committee when we've received the RAISE report and we've agreed any subsequent actions. Look, this isn't. I don't think this is a time. This is about the families of the Omagh bombing. To be honest with you,
I don't want to take away from that, but I think there has to be an acknowledgement from this committee the shortcomings we have come up against, and we hope the Omagh bomb inquest will not suffer the same. Listen, if you want to put it to a vote, if it fails, it fails.
I just think, and you know, I can hear your sentiments, Timothy, and we've discussed them quite at length in various areas around this. But this is about the case in point, which is the victims of the Omagh bomb and the process that they're currently engaged in, the painful process that they're going to experience, and us wishing them well and acknowledging that they've met, they're coming to this milestone now of having this case going forward, and it's really all of that there. It's the focus on them at the minute, and I think anything else is just a distraction really, and it's maybe not in their best interests that we would do that. And again, we're back to doing no harm, and I don't think we want to do any harm.
I wonder, as a compromise, and I don't know whether I need to put that to the vote first, but I wonder if the final line there, and we urge full cooperation from authorities on both sides of the border so that the whole truth can be obtained.
Or I think it's fair to say also, and I wholly agree with you, this is about the families and the incident, but just in the background of all of this, the Thomas was here yesterday and he made that pledge. He said the Irish government would cooperate.
Okay. So I'm going to put Timothy's suggested amendment to paragraph to the vote, and then my suggestion, and then the original. Am I right here, Clerk? Am I
Yes,
right?
fine.
Okay.
Yep.
So who wants to include the full paragraph that Timothy has suggested? Okay. So we have Timothy, just one. Who wants to include my compromise around just including that final line?
Yeah.
Okay. So that's the majority. Is that okay?
Okay. So I just have one member not voting.
Well,
On screen.
1, 2, 3, 4.
I think it was
yes,
everyone else.
and the other members.
Yeah.
Yes. So I'll note in the minutes how
Okay.
people voted.
The amendment carries.
The amendment carries. Thank you, and thank you for bringing that forward. Right, members, just getting back online then. The other issue I want to raise is the change in the administration, the US government, that concerns around what implications that will have in terms of peace and reconciliation funds that our cross-community community organisations are in receipt of at the minute, and there's potential implications of that work. I'd ask your agreement that we ask RAISE to pull together what funds we get from America, whether it's peace and reconciliation or youth capacity building and stuff, to see what could potentially be impacted in terms of our role in terms. Is that okay? If we can...
Sorry, I missed the start of what you were
So-
saying there.
so-
Is that relating to an item of correspondence? that you
No,
know?
no, no. So what I'm saying is, you'll have seen in the media in the last few days that Trump has put a freeze on federal funding going to overseas aid and programs and stuff. And what I'm saying is that we know that there's some funding that comes to Northern Ireland to help with our peace and reconciliation. So it was really just to see if Ray's could have a look to see what the size of that is, and what the potential implications would be in terms of our grassroots community work. Is that okay? It's really just to get a understanding of it. Okay.
It would also be helpful, Chair, if we saw it from our executive office bureau in Washington, a readout on that situation as well. We could perhaps write to them.
Yes. So is that in relation to support for Northern Ireland? Yes. Okay. Thank you. Okay. So draft minutes, they're in pages 24 to 30 of your pack. Are people content with them? Okay.
Yeah.
So matters arising then. So there's some information there on the Council of Europe, their motion into child abuse. I thought it was excellent. Thank you for bringing that to our attention. Stuart, I thought that...
Interesting to note that the Swiss have agreed a compensation scheme, and it's double that of the United Kingdom.
Yeah.
It's £22,000 per individual.
Yes, I thought that use of the word reparation as opposed to redress was good.
As
yeah,
well, yes.
To reflect the seriousness. Okay.
Just on that,
yes, go ahead.
Certainly, they seem to be taking more of a forthright approach on it. 7.6 encourage and support non-state institutions caring for children and operating on the national territory to assume their responsibilities and ensure that their responses allow full reparation for all violence committed against children. Page 43. In the SAV Commission, is that the correct pronunciation?
We'll take it.
View, the Church must take responsibility both individually and systematically. Responsibility must apply both individually by reason of a particular role exercised by the individual and to those who have not committed acts of abuse, but with whom, through the legal relationship existing between the perpetrator and the bishop of the perpetrator's diocese, they are linked. According to this report, or the report, all the legal entities within the Church should be able to be held criminally and civilly liable for the misconduct of its components, ministers or members. The judicial ability of the Church can also extend to the judicial liability of natural persons in positions of authority within the Church, foremost amongst whom are bishops and major superiors of congregations. I certainly feel that if we had taken that approach from the word go, there'd be a more robust response from the Northern Ireland Executive TEO, and we wouldn't be run about chasing some institutions who are giving us their runaround, who won't come to committee. We don't know if they're going to pay the money, whereas this is certainly more robust and it's certainly welcome and good reading.
Yeah, well, it very much speaks to a legislative approach. I think the other thing that jumped out at me was that they said that member states should conduct an independent and comprehensive scientific investigation into the violations of children's rights, and promote public discussion on this issue. I wonder, are any of the universities actually looking at this? I don't, I don't know how we would take that forward. I just think that... go ahead.
The final comment, paragraph 34, the SAV Commission stressed that the necessary funding should come from the assets of the perpetrators and from those of the institutions belonging to the Church in France and exclude any appeal for donations from the faithful, whereas we are running around thinking about affordability. Whereas if there's assets there, what it's talking about in this document is going after them, and that's certainly the way it should be.
You reminded me there. I think that they need to stop talking about affordability considerations. I forgot about that. I was going to raise that when they're spending so much money on everything else. Yep.
Oh, that's
okay. Where am I? Okay. No, thank you. Where am I? Right. So that's the end of matters arising. Draft forward work programme. Were members content with that? Again, I think we've added in today the Truth Recovery Independent Panel.
Chair, could I make 2 points in that and also ask if we could go into private session for 2 minutes once I make the first 2 points? Women's Rights Network and Christian Institute have been invited to be on the same panel.
Okay.
Certainly from my understanding, Women's Rights Network are coming here to talk about gender, whereas Christian Institute, it's not focused on gender, but it's a case of bringing their expertise. We think of the Asher's case, where they took the case against the Quality Commission and won, whereas two separate things. And if you want to have, I believe it should be two panels, whether you want to split it up, but I think they should be sitting, giving evidence separately, so we're not conflating gender and potential implications for faith-based organisations.
Okay, sorry, you're absolutely right. I jumped past trying to get through this, the update on the equality legislation inquiry. So the Christian Institute wrote and they made a written submission, and they also attended that session. So they have had an opportunity to feed in, both verbally and in writing. And so to give them then a third bite where other organisations have not been afforded that, we're trying to close down the committee inquiry. We were trying to facilitate this additional session, because I know not everybody could get to that roundtable event in December in the Long Gallery. So it's on that basis really that we were trying to move this forward, because if we have the Women's Rights Network, that's maybe an hour, and then the Christian Institute, but yeah.
Well, if they've been, they've been.
Well,
Well, sorry?
If they've been, they've been.
We've reached out to them, and I don't think you can rescind that.
No, I'm not asking to rescind. I'm saying
But
that
if you could
our
split it
proposal-
into two different sessions instead of appearing on the one panel, because you'd be asking one side about gender and one side potentially about impacts of faith-based organisations. I just don't think the two topics coexist in the one panel.
Chair, it was just a thing on constraints on committee time, and we were fitting them in as an extra panel anyway, and that will be three sessions that day, which the committee I think has frowned upon in the past. So it's about constraints on committee time, but it's up to members what they want to do on that occasion.
If you're inviting opening words, one will take potentially 10 minutes, the other could take 10-15 minutes. That's two different topics they're talking about, whereas I think it would be more neater if you have to move it to two 45-minute panels or two half-hour panels.
Okay, well, we can work out. We can give them two reduced. I'm not going to nickel over that. We can maybe just give two reduced then on the day.
Yeah.
Is that okay? And then people will be conscious of that when they're asking their questions. Is that okay?
Yeah.
And ask for papers up front to
Yes.
make sure then we get that.
Okay.
Certainly the Christian Institute chair did attend the event,
Yeah,
and
that's right.
I was at the table with them, and they made some good contributions on the day.
Okay. So, on the basis that they are coming on the 12th of February, then I would like agreement then that we can organise a closed session on the 5th of March so that we can consider an options paper and committee recommendations. Everybody content? Do you want to go into closed session now?
Just for 2 minutes.
Okay, can we go into closed session? Is committee in agreement that we go into closed session for 2 minutes?
Yeah.
Okay, go ahead, thank you.
Committee Room 30. Sound. 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 Committee Room 30, 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 sound.
Correspondence then. Page 287 of your pack, you'll see that there was correspondence from the Law Society in relation to the HIA Redress Board. Just want to seek your agreement that we can send that response to COSIGA, and also I think that should we not also send it to the 3 Rosetta Trust, Northwest Survivors and Survivors Together? Yeah. Is that okay? Yeah. Okay.
Yeah.
So there's a briefing on January monitoring in your pack, and just seek your agreement that we would ask the department to come in and give us a briefing on the 2024-25 budget. Just for the
Great.
Yeah. Okay. Any other correspondence that anybody would like to raise? No. Okay. So thanks, members. Same time, same place next Wednesday. Thanks very much. Thank you.
Committee Room 30, sound. Committee Room 30, sound. Committee Room 30, sound. Committee Room 30, sound. Committee Room 30, sound.